Good morning. Welcome to today's webcast. My name is Gigi Au. I'm an associate from the Environmental Planning and Local Government Group at Matthews Folbick Lawyers at Parramatta. And I'm presenting to you today on the topic of costs in Class 1 proceedings. Is it fair and reasonable? In civil litigation proceedings, an award of costs will generally follow the result of litigation, the winning party being entitled to an order for costs against the losing party. This rule in legalese is called costs follow the event. However, this general rule does not apply to Class 1 proceedings in the Land and Environment Court. Instead, there is a presumption that the court does not make cost order and each party is expected to pay their own legal costs. Rule 3.7 of the Land and Environment Court rules applies to Class 1 proceedings as well as Class 2 and Class 3 proceedings. This rule provides that the court is not to make any order for costs unless it is satisfied that it is fair and reasonable in the circumstances to do so. Rule 3.7 also provides a list of circumstances that a court may consider when determining the question of costs. The list, however, is not exhaustive, and the court may look into other factors it deems fit. In this webcast, I will discuss the method and timing in which the cost application is made, the factors in Rule 3.7 that a court would consider when deciding whether it is fair and reasonable in the circumstances to make an order for costs, using examples from recent case law. Towards the end of this webcast, I will answer questions, so please feel free to send in your questions. Let's begin. How does a party go about making an application for costs in Class 1 proceedings? In most litigation proceedings, the winning party often makes oral application for costs at the conclusion of the hearing and when judgment is handed down. And because costs usually follow the event, the court is likely to award costs to the winning party. However, it is different in Class 1 proceedings. Firstly, because of the presumption that costs do not follow the event. Secondly, the party seeking costs is also required to file an application by way of a notice of motion. A notice of motion is a document outlining what the party is seeking the court to do. It is filed with an affidavit in support, giving the reasons for the application. It is important to note that there is a time frame in which a notice of motion seeking costs must be filed. Because the nature of the application, which is usually made after the court has handed down his judgment, a cost application in a Class 1 proceedings is considered as seeking a variation of the judgment. Rule 36.16 of the UCPR, which is the Uniform Civil Procedural Rules, provides that a notice of motion of this sort is to be filed within 14 days after judgment or order is entered. And this time frame of 14 days cannot be extended by the court, which means if a notice of motion is filed out of time, outside this period, it cannot be considered by the court. So what does it mean by the 14 days after judgment and order being entered? This may sound like a simple question, but I have seen applicants filing notice of motion some months down the track after the original judgment is handed down. Rule 36.11 in the UCPR states that a judgment or order is taken to be entered when one of these two things happen. It is recorded in the court's computerized record system, or when a document embodying the judgment or order is signed and sealed by a registrar. That is, judgment is taken to be entered when the written judgment is handed down in court or when the written judgment is uploaded to the court's online system. However, things are not always that straightforward. I have been previously involved in a matter where we acted for counsel and was successful in defending the applicant's cost application. In a matter of TL and TL Tradings and Parramatta City Council, where the applicant was an operator of a brothel. Previous development consent was granted for the brothel to operate for a 2-year trial period, and any extension of the trial period would be subject to a Section 96 modification application, which is now the Section 4.55 application. Shortly prior to the expiration of the trial period, the applicant lodged a modification application to extend the trial period, but was refused by counsel for various reasons. The applicant then filed the Class 1 appeal. During the Class 1 appeal, this is in November 2016, Justice Moore, after hearing the case, adopted an amber light approach and allowed the brothel to resume operation, but subject to some major revision of the plan of management and physical adjustments to the premises, both internal and external, one of which was to improve the lighting outside the building. The parties spent almost a month in revising the plan of management and agreeing on the conditions of consent. Until December 2016, the court formally entered the final orders regarding the appeal, the amended plan of management, and the condition of consent. The court also ordered that the brothel was not to resume operation until the physical adjustments were dealt with to the satisfaction of the counsel and to the court. The applicant did not immediately file the notice of motion seeking costs until some 8 months down the track. The applicant argued that it was only appropriate to deal with the issue of costs until counsel was satisfied with all physical adjustments and the brothel resumed operation. At the hearing of the notice of motion, counsel argued that the 14-day period started on the 20th of December, when the final orders were recorded in the court's computerised record system. Hence, the applicant's notice of motion is out of time, and the court has no jurisdiction to consider it and should be dismissed. The court did not ultimately decide on this issue, partly because of the large amount of material filed by the applicant. Justice Moore was minded that it was more appropriate to first determine whether it was fair and reasonable in the circumstances to make a cost order. And if the applicant did not pass the fair and reasonable test, then there would be no need to decide on a timing issue. The court ultimately dismissed the applicant's application and found that the outcome of the Class 1 appeal did not give rise to an event in which the cost should follow, let alone the fair and reasonable test pursuant to Rule 3.7. The court found that there were defects in the applicant's original modification application, being the subject of the Class 1 appeal, which would have been doomed to failure. The partial success of the applicant to resume operation was due to the extensive modification of the plan of management. Also, the further trial period granted was significantly shortened from the applicant's originally desired. Hence, the court found that there was no rational basis to consider the outcome of the Class 1 proceedings being an event that costs should follow. The court dismissed the cost application. Because we promptly served the applicant with an offer of compromise, inviting the applicant to withdraw its application, and counsel was ultimately successful in the hearing, the court also awarded costs in favour of counsel, as agreed or assessed up to a date of the letter of offer and on an indemnity basis thereafter. This is a very good result for counsel. Now that we have discussed the timing and the method, let's move on. Assuming a party has filed a notice of motion within time and the court has jurisdiction to deal with it, let us now look at the question, is it fair and reasonable in the circumstances to make an order for costs? As I said earlier, the Land Environment Court Rule 3.7 provides a list of non-exhaustive factors that the court may consider when deciding whether or not a cost order should be awarded. The circumstances can be summarised as follows. Number 1, whether the main proceedings involve, as a central issue, a question of law, a question of facts, or a mixture of two. Number 2, whether there is any failure or unreasonable delay on the part of a party in providing materials required by law or materials required by the consent authority to properly understand a case. Number 3, the reasonableness of a party's conduct leading up to the proceedings. Number 4, the reasonableness of a party's conduct during the proceedings. Number 5, whether a party has commenced or defended a case for an improper purpose. And lastly, whether a party has brought a case without reasonable prospect of success, or a party has maintained a claim or defence that was unreasonable in all circumstances. I will now go through each circumstances and give examples with case law. Let's turn to the first circumstances, questions of facts or law. Most Class 1 proceedings are what known as merit reviews, where the commissioner of the court step into the shoes of the counsel and determine whether a development consent should be granted. In cases that involve, to a substantial degree, questions of facts or questions of law, instead of a merit review, it is more akin to a normal civil proceeding, and costs should follow the event. Let's look at some cases to see how this factor is applied in practice. In Kinder Investments and Sydney City Council, a consent was approved by the council in December 2002 to increase the number of floors in a commercial building, together with some associated works. One of the conditions was that the consent would only be valid for 2 years, meaning the consent would lapse in December 2004. So in September 2004, realising that they won't be able to commence the development on time, the developer wrote to council seeking to extend the development consent. The council agreed to extend the development consent by 1 year under the former Section 95A of the EPLA Act. This section allowed the council to extend the consent period by up to 1 year if the original consent period is less than the statutory maximum of 5 years. About 1 year later, the developer came knocking on council's door again with another request for extension of the development consent. Rather than relying on Section 95 again, the developer filed a Section 96 modification application seeking to extend the development consent. This was refused by council. The developer then commenced proceedings appealing council's refusal to modify the consent. The question before the court was therefore whether the former Section 96, which is now Section 4.55 of the EPLA Act, can be used as a backdoor for the council to grant further extension of time for the lapsing of the development consent. The answer by the Chief Judge was an emphatic no, because this would defeat the purpose of the former Section 95A. In this case, council sought a cost order against the developer, relying on the factor that substantive issue of the proceedings was a singular legal question, and therefore costs should follow the event, like all other civil cases. His Honour agreed with council's submission and ordered the developer to pay council's costs. Now let's look at the second circumstances. Any failure or unreasonable delay on the part of a party in providing materials required by law or materials required by the consent authority to properly understand the case. In the matter of Bruyan and Hawkesbury City Council, the court granted consent for the subdivision of a piece of semi-rural land. The condition of consent stipulated certain requirements regarding an on-site waste disposal system. In the following year, the developer made an application to council seeking to modify the condition of consent, to modify the design of the on-site waste disposal system, and was refused by council. The developer subsequently filed a Class 1 appeal. The problem for the developer was that the expert material attached to the Class 1 application was only a letter from the town planner. That letter had failed to provide reason why the design needed to be modified. The developer also failed to file an amended statement of environmental effect until very late stage in the proceedings, despite the many requests from council, and also when they were aware this was one of the main reasons council refused the application. Ultimately, the modification application was allowed by the court, and both parties filed a notice of motion seeking the other party to pay their costs. Council argued that had the developer lodged the statement of environmental effect and provided reasons supporting the proposed modification to the waste disposal system, there would have been no need to commence the proceedings in the first place. The court ultimately found that because the delay of the applicant in filing the amended statement of environmental effects, the council was not able to reasonably understand the developer's case. Therefore, His Honour ordered the developer to pay the council's costs in the proceedings up to the date when the amended statement of environmental effect was filed. Now let's turn to the next factor. That is, whether a party had acted unreasonably in leading up to the proceedings. The example that I've chosen is a Class 2 tree dispute between neighbours. Well, whilst the nature of the application is very different to a Class 1 appeal, the factual circumstances in this case will assist because Rule 3.7 also applies to Class 2 proceedings. Now, Mr. Smith and Mr. Smith resides in Castle Cove. Behind their house is this land owned by their neighbour, Mr. Zhang, where there was a big blue gum tree. In March 2009, Mr. Smith noticed some cracks on the wall of his house and engaged a structural engineer to investigate. The structural engineer formed the view that it was caused by the blue gum tree on Mr. Zhang's land. Mr. Smith then filed a Class 2 application seeking order for the blue gum tree to be removed and sought compensation from Mr. Zhang. Mr. Smith lost the case as he failed to convince the court that the tree had caused the problem. In September 2015, Mr. Zhang sold his property to the Kaduas. After some unsuccessful negotiations between Mr. and Mrs. Smiths and the Kaduas, the Smiths filed a second Class 2 application against the Kaduas. This second case was again dismissed by the court, and the Kaduas filed an application seeking costs against the Smiths. The court found that a few events that happened before the commencement of the Class 2 proceeding were relevant for consideration. Firstly, prior to the Kaduas purchasing the land, the Smiths wrote to their former neighbour, Mr. Zhang, offering to pay for the removal of the tree and the cost of the associated development application. Secondly, shortly after the Kadua's purchase of the land, they informed the Smiths that they were happy for the tree to be removed, provided that the Smiths agreed to indemnify them against any damage caused by the tree removal. The Smiths rejected this offer and filed proceedings in the court. Justice Payne, who heard this notice of motion for costs, found that the Smiths had acted unreasonably leading up to the commencement of the second proceedings and ordered them to pay 50% of the Kadua's legal costs. From this case, we can see that pre-litigation discussions, settlement negotiations, and a party's conduct could be relevant for consideration when determining a cost application. Let's have a look at another case. In Agonic Holdings and Lithgow City Council, the council refused a DA proposing subdivision of a farmland. The developer subsequently filed a Class 1 appeal and was successful. The council refused the DA after seeking advice from the Department of Primary Industry, DPI. Whilst DPI was not a concurrent consent authority, the council argued that it was its policy at the time to refer certain subdivision applications to the DPI. The DPI provided expert evidence on behalf of council that opposed the subdivision because the subdivision lots would be too small to allow certain scale of agricultural production. This was council's main reason for refusal. In response, the applicant argued that council had been inconsistent with its approach, and it was evident on numerous occasions that council did not refer similar subdivision applications to the DPI. One of the questions before the judge was whether the council had acted so unreasonably in lead up to the court proceedings by referring this development application to the DPI, when it did not do that with other similar applications. The court found that council had not acted unreasonably. Firstly, the court found that the developer's argument regarding council's inconsistency in referring similar subdivision applications to the DPI was debatable. Secondly, perhaps more importantly, the court found inconsistency in decision-making did not, by itself, make council so unreasonable that it would be liable for a cost order following unsuccessful Class 1 appeals. Justice Biscoe went on to say that consistency in all circumstances may deny a consent authority the opportunity to change its mind when it ought to do so in the interest of good planning. The court also found that the DPI, being a higher government body, it was appropriate for council to give their opinion some significant weight. As such, the court did not find for the applicant and did not make a cost order against council. The next circumstances we will look at relate to the party's conduct during the proceedings. This is a rather broad factor, and we will look into a couple of examples. Firstly, what happens when a party withdraws the case halfway or late in the proceedings? A couple of years ago, Matthews Folbig acted for Horoid City Council in the matter of Koori, where the council issued an order against Mr. Koori for the illegal use of his property as a boarding house. Mr. Koori was self-represented and appealed the order at the Land Environment Court. The matter proceeded to Section 34 conference and later to a hearing. During the course of the proceedings, Mr. Koori failed to comply with a number of court orders relating to the filing of a statement of facts and contention and evidence, and he continued to ignore those orders leading up to the hearing. On the day of the hearing, the matter came before a commissioner. Mr. Koori was not happy with the arrangement and applied to have the matter adjourned and transferred to a judge. This request was refused by the commissioner. And following some exchange of conversation, Mr. Koori simply walked out of the courtroom, and the matter was heard in his absence. The council was subsequently successful in the proceedings, and following that, council made an application for costs. The notice of motion was heard by Chief Justice Preston. His Honour had regard to the fact that Mr. Koori did not inform the court or the council of his intention to withdraw the matter until the first day of the hearing, which forced the council to expend significant costs in preparing for the hearing. His Honour found that it was fair and reasonable to order the applicant to pay the council's costs. But it is interesting to note that a party withdrawing late in the proceedings does not always result in a cost order against him. In the next matter, Ross and Lane Cove Council, a consent was granted by council to Mr. Ross for the construction of a house. During construction, Mr. Ross carried out a number of unauthorised works, which included the construction of a concrete awning. Some 5 years later, the council, upon discovery of the non-compliance, wrote to Mr. Ross, inviting him to submit a Section 96 modification application. Mr. Ross, in response, offered to apply for a building certificate instead, but this was rejected by council. Subsequently, the council commenced civil enforcement proceedings against Mr. Ross for breach of the condition of consent. Mr. Ross unsuccessfully sought a stay in the enforcement proceedings and lodged a Section 96 modification application. Well, this application was later refused by council due to lack of sufficient information. Mr. Ross then commenced a Class 1 application. In the Class 1 appeal, the council raised a contention contrary to their letter to Mr. Ross and said the concrete awning could not be retrospectively approved by way of a modification application. As it was made, it will make the house substantially different from what was originally approved. On the first day of the hearing, the Commissioner indicated that he was minded to uphold council's contention in relation to the awning, as it would make the development substantially different. And he was also minded to order for the awning to be removed. noting that Mr. Ross removed the concrete awning from the drawings and made a notation that the awning did not form part of the application. The hearing was then adjourned until after Christmas. When the hearing resumed, it transpired that Mr. Ross has misunderstood the Commissioner. What the Commissioner had intended was to order Mr. Ross to demolish the awning after the case was determined. Desperate to keep his awning, Mr. Ross went down to the registry and withdrew the case in order to prevent the Commissioner from making a final order. After Mr. Ross withdrew the case, Council filed an application for costs, and this was refused. His Honour found that Council was partly to blame for Mr. Ross' discontinuance of the proceedings, as Council had refused Mr. Ross' offer to apply for a building certificate, and then argued that it was not appropriate to retrospectively approve the awning by way of a modification application. His Honour also found that it was not unreasonable for Mr. Ross to have misheard or misunderstood what the Commissioner said regarding the removal of the awning. As such, it did not find that reasonable to award any costs. As we can see, the Court takes into consideration the reasons leading up to this continuance when determining whether to make a cost order. Now let's move on to the next circumstances, which relates to a party bringing or changing arguments late in the proceedings. In 2009, the Noun family lodged a DA with Sutherland Shire Council, proposing some modification work to their home at Caringbah. The previous owner of the property had some 10 years ago sought development consent to do some renovation work. At that time, the council imposed a condition requiring a boat shed to be demolished within 10 years from the date of approval. Although the renovation was carried out, the boat shed was never demolished. During that time, a previous owner also installed 2 fender piles, which council was not aware of. In 2009, council approved a DA to the Noun family. Council reimposed the condition for the boat shed to be removed. In order to keep the boat shed, the Noun family filed a Class 1 application. The council's town planner, during joint conferencing, noticed the fender piles and formed the view that they should be removed. Council then served the without prejudice condition, adding a new condition requiring for the removal of the fender piles. And then on the first day of the hearing, Council sought leave from the court to bring this into contention. As a result of Council's late introduction of this contention, the hearing was delayed to allow the parties to obtain further expert evidence. Ultimately, the Noun family was successful in the appeal and filed an application for costs. In her honest judgment, Justice Payne agreed with the Nouns that Council had acted unreasonably by failing to include the fender piles contention in the statement of facts and contention, and then pressed for their removal late in the proceedings. From this case, we could appreciate the importance and significance to include all contentions right from the start. Next, we will look at cases where a party had commenced or defended a case for improper purpose. In statewide development and Minister for Infrastructure and Planning, the developer argued that the minister had maintained an emergency order and defended the Class 1 appeal for improper purpose. The development related to the construction of some interconnected residential buildings in roads. The development consent for the building work and remediation work was granted in June 2004. In March 2005, the minister issued an emergency stop work order requiring the developer to stop all excavation and remediation work after discovering that they had breached condition consent. Although the minister's office was later aware that the developer had subsequently rectified the issues, the minister refused to revoke the stop work order unless the developer provided an undertaking to carry out further stages of the remediation work in accordance with the original consent. And if the developer is unable to comply, then they should immediately file a modification application. The minister further threatened to commence civil proceedings against the developer for breach of consent. The developer commenced a Class 1 proceedings seeking to remove the stop work order. The developer was ultimately successful and filed an application for costs. In the cost application hearing, the court found that the minister's refusal to revoke the stop work order in an attempt to force the developer to give undertaking as to the next stage of work was not a proper purpose for maintaining the order. Accordingly, the minister was ordered to pay part of the developer's legal costs. In the next case, Community Association and Volara Council, the applicant was not successful in its application, although it was successful in challenging the validity of a development consent condition. For the purpose of maintaining public view of Double Bay area, Council imposed a condition of consent requiring the applicant to build and maintain stairs in an area of private foreshore and open this area to the public during certain hours of the day. The applicant maintained its stairs for some 8 years, but then after receiving complaints from the residents, the applicant closed the stairs and the viewing area. After the stairs closed, the council issued a number of non-compliance notices to applicant. The applicant subsequently filed a Class 1 appeal, and the court found that the public access condition should be removed. The applicant filed an application for costs. The applicant argued that council seeking to gain public access to private foreshore land under condition of consent is an improper purpose, and it should have acquired the land by way of compulsory acquisition. This argument was rejected by the court. The court found that whilst the council's public amenity planning objectives turned out to be incorrect in a legal sense, did not give rise to a finding of improper use in the cost sense. For this reason, the court did not order the council to pay the applicant's costs, even though council lost their case. The next circumstances we'll look at is bringing case or maintaining a case with no reasonable prospects of success. In Broadwater Action Group and Richmond Valley Council, the proposed development related to the construction of an electricity generator that turned waste products from a sugar mill into electricity. Following council's approval of the constructions of the generator and some associated works, a local activist group filed a Class 1 appeal challenging council's decision. The main argument relied on by this group was that a certain statement should have been filed with the DA. The group also argued that the proposed development could have impacted on a number of endangered species in the area. Justice Lloyd in the Class 1 proceedings found against this group. His Honour also put little weight to the evidence of environmental impact submitted by the group. After succeeding the Class 1 appeal, the council sought costs against the activist group on the basis that the group had commenced proceedings for improper purpose and without reasonable prospect of success. At the cost hearing, Justice Lloyd examined the conduct of the activist group in the course of the proceedings. In particular, the misrepresentation or misinterpretation of the applicable law and lack of evidence. His Honour found that the group had acted capriciously, willfully disregarded the known facts, and established law in instituting and continuing proceedings which were hopeless, and ordered the group to pay council's costs accordingly. The next factor is opposite to starting a hopeless case, where the respondent council has maintained a defence unreasonably. This case we'll look at is between Mr Dunford and Gosford City Council. Mrs Dunford sought development consent to demolish an existing building and to construct a new one. Council refused the application, firstly because the construction of the dwelling did not sufficiently avoid or minimise the potential risk of coastal erosion. Secondly, it was in the public interest as the development would likely to be impacted by coastal hazard, causing future property damage and loss. Although Mrs Dunford offered to address the second contention by building a revestment wall, which would help to combat the effect of coastal erosion, this offer was refused by the council. During the course of the proceedings, it transpired that counsel's own expert agreed that the development application was compliant with the controls and the EPIs, and agreed that the proposed development was not contrary to public interest, as long as certain measures, such as a revestment wall, were put in place. It also turned out that council had at the time been actively pursuing its own policy of building revestment walls. And notwithstanding this, the council maintained its contention and ultimately lost the Class 1 appeal. The applicant made an application for costs. In the cost hearing, Justice Sheehan was very critical on the way that council had handled the matter. In particular, His Honour found that council maintained the defence unreasonably when its own coastal engineer accepted the development application was compliant and departing from its own policy of building revestment walls without any good reason. And on this basis, the court made an order against council. We have just gone through many examples to see how Rule 3.7 had been applied in the past by the court when considering the question whether it is fair and reasonable in the circumstances to make an order for costs in Class 1 proceedings. To summarise today's webcast, here are some of the points to take home. A party seeking costs must file a notice of motion within 14 days after judgment or order is entered. And also there is a presumption rule that the court does not make an order for costs in Class 1 proceedings unless it is satisfied that the circumstances that it is fair and reasonable to do so. Rule 3.7 provides a list of circumstances that the court takes into account. And these circumstances are the nature of the proceedings, the conduct of the parties, whether a party has acted unreasonably leading up to the proceedings and during the course of proceedings, and whether the party has commenced proceedings for improper purpose or maintain a hopeless case. The court may look into other circumstances it sees fit. As with all litigation, the court ultimately makes a determination, and the merits of each application depend largely on its own facts and circumstances. It is important to remember that cost applications should not be brought lightly, as the losing party of the application could be ordered to pay the winning party's costs. As such, we recommend counsel seek legal advice before making any such application, and when an application is made against counsel. That concludes the main part of today's presentation. We have some time for questions. Let's have a look at some of the questions that I've received. Okay, the first question. What is the rationale behind this no-cost presumption? This is a very, very good question, and I'm sure a lot of people have asked this question before. As I remember it correctly, in the matter of Arden's Anglican School and Hornsby Council, His Honour answered this question. But there is actually a no discouragement principle underlying this presumption, that a person who should not be discouraged from exercising its rights of appeal in planning appeals because there might be a cost order made against him or her. This is quite different from normal litigation matters where the cost order is really to encourage the parties to settle. So from what we can see just then, the court looks into different circumstances when considering this question of costs, and all rational circumstances will be considered by the court as a whole to decide whether it's fair and reasonable to do so. I hope I've answered your question. Now let's have a look at the second question. Okay, the second question is from Nina. How much costs are usually awarded by the court? Okay, I presume that is to the topic that we're talking about, Class 1 proceeding costs. This is, again, a very interesting question. I probably don't have a definite answer, but I'll try and work out what actually determines the amount of costs. Well, as with all litigation matters, the amount of legal costs incurred really depends on the nature of the proceedings, the facts of each proceedings, and the arguments put forward by the parties, and maybe the conduct of the party as well. So for example, if you've got an opponent who argues with every law, every facts, sent many correspondence that as a respondent counsel would need to address and respond to, the matter will no doubt be dragged and resulting in more legal costs. The length of the notice of motion can also vary. I've been to notice of motion of costs where it was as long as, if not longer, than the substantive Class 1 application. And it also depends on the grounds that the applicant of costs is relying on when they make the Class 1 cost application and the amount of evidence filed with the application. So I would say the amount of costs vary on a case-by-case basis. Let's have a look. We've got time. Let's have a look at the time. Okay, we've got time for another one. What does costs as agreed or assessed mean? Wow, this is a very good question too. And we often heard costs as agreed or assessed. What does that actually mean? It means that costs can either be agreed by the parties or as assessed by the court. So what happens is when the cost order is made, the parties come to negotiate the amount, and if they can agree on the amount, that's really good. But if they can't, then the cost applicant can file an application, which is called a cost assessment application at the Supreme Court to have its costs assessed. Once the cost is assessed by a cost assessor, then they issue a certificate of determination. And then this certificate can then be registered as a judgment, and this judgment can then be enforced like a normal debt. I hope I answered your question. I've got 2 minutes left. Okay, how about I answer one last question? Okay, this is a very good one. Is cost thrown away the same as the costs we talked about today? The short answer is no. Cost thrown away is the cost wasted by counsel in considering the original plans when an applicant is granted leave to file new plans. So these costs are used to called Section 97B costs, and it's now Section 8.15 costs under the amendment of the EPLA Act. And these costs are usually only awarded to not minor amendments. So they don't apply to minor amendments. And this is usually when agreed upon by the parties when the applicant files a notice of motion and counsel says, okay, you can rely on these amended plans provided that you pay our costs. Looking at the time, that concludes our webcast today. And thank you for registering, and I hope you have found this webcast helpful. If you have any further questions in relation to this topic, please contact me or my colleagues at Matthews Folbig Lawyers. Have a good afternoon.